Hello, everyone. Welcome back to the eDiscovery channel, and we've got a star-studded all Baltimore panel here today. It's myself, who went to college in Baltimore, and
We'll count you in, I guess.
yeah, it's close. I was a substitute teacher in the Baltimore school system my senior year.
Oh, then you're definitely in.
That's not a trial by combat. I don't know what is.
Yeah.
Um, and Rachi, of course, is a Baltimore native currently residing in Tel Aviv. But you mentioned you're in Baltimore now at your brother's house, I take it?
I am.
Getting ready to go up to legal the 3-day show called Legal Week.
Legal week,
That.
exactly.
Yeah,
Yeah.
but whatever, because it takes you a week to get in, counting getting in and out of the city. Uh,
That it
um,
does. That
are
it
you
does.
guys? Do you
Yeah,
guys
and it takes a
train up?
week, and it takes a week to recover. That's
Yeah, exactly. Do you guys take the train up from
yeah.
Baltimore? Yeah.
Yeah, we just hop on the train. We're there in 2 hours.
Ah,
Good to go.
the only way to fly.
Yep.
And we are really happy to have with us someone I've been trying to entice to submit to our grilling for a while now. Attorney Michael Berman, who works in Baltimore, well, we'll ask you if you grew up. I don't really know, but you can give us some background in a second, Michael. But he's got practicing attorney of counsel with Rifkin Weiner Livingston. Is that still accurate, Michael?
Yes, it is.
Yeah, but his own operation is E-Discovery LLC. If you've seen any postings on the internet about e-discovery cases, and just had something about, I think you had something this morning about the Florida bar's AI opinion.
Correct.
It's a great resource and highly recommended. He also teaches as an adjunct professor at the University of Baltimore School of Law since what, 2007, 2008? It's been a while.
Yeah, about 2007.
Yeah. And is the school still across the street from the train station?
Close by, they have the new Angelos building, which is a modern all glass
Gorgeous building. Gorgeous
structure.
building.
Really? Okay. Okay.
The wind shades go up and down on their own. It's all artificial intelligence. It's all electronically controlled.
Of course, it's artificial intelligence. What isn't these days? So, and I know, and correct me if I'm wrong on this. Maryland does not allow self-designation or designation by other people of attorneys as a specialist, right? There is no specialization. If anybody could be called an e-discovery specialist in the state of Maryland, it would be you. But I won't do that. It's not allowed by the
A non-specialist in
That's right.
e-discovery.
That's right.
A fan.
So Michael, tell us, as I just alluded to, tell us a little bit about yourself growing up. Where did you grow up? Go to school? What was the progression into not just the law, but this wacky business of litigation support and e-discovery?
Sure. I grew up in Silver Spring, Maryland. My parents moved there after Dad got out of the Army, the Second World War. And he went to work for the government, worked at the Pentagon as a civilian for decades.
Oh.
Went to what was then called junior high school, now middle school and high school in that area. When I graduated high school, like all kids that age, I had a debate with my parents, and I got accepted to USC and wanted to go to California. They thought it was too far away, and I got accepted to the University of Wisconsin. So we compromised, and I went to Wisconsin. It actually took longer to fly to Wisconsin than
yeah, Madison. You're at the Madison camp. Yeah, yeah.
And I was so naive. Freshman semester, I was walking down the street with my roommate from Chilton, Wisconsin, and I saw the big bank sign and had the temperature at plus 18. And I said, Lee, why does it say plus? And he just started laughing. So the temperatures would hit 20 degrees below zero. But Wisconsin was great. It was, I graduated in the 70s, so it was a very politically active.
Yeah, I was going to say that was quite a time in Madison. Yes.
Yeah. My first lecture, I walked out of an underground lecture, walked into a parking lot, saw a big crowd, walked over to see what was happening. A guy jumped up in the car and said, off the pigs. Something went flying through the air. It's a tear gas grenade. And that was my introduction to college. Nevertheless, I did graduate. I went into the Army for 4 years, 4.5 years after that.
Ah, were you
And-
ROTC or you just?
Yeah.
Yeah. Okay.
Yeah.
Well, that must have been a
Mhm.
popular course at
But I spent 19 months in Korea, 12 of them up with the 2nd Infantry Division up in the north part of the country.
Mhm.
And that was a fascinating experience. And then when I got out, I decided I really had to do something with my life. So I went to graduate school at College Park on the GI Bill, got a degree, a master's degree, and they called it Urban Studies. It was really political administration of cities. And as one of our exercises, we had to write a paper on a contemporary topic and go talk with local city managers. So I wrote a paper on zero-based budgeting. And I went to the city manager of Rockville and I presented it to him. And he said, you know, Mr. Berman, it's fascinating. It's a great idea. If I ever presented it to my city council, I'd be fired immediately.
Right.
So I decided I really had to do something. And I had 3 years left on the GI Bill. My dad had been a lawyer. My brother-in-law was a lawyer. And I decided to go to law school. So I applied.
And sorry, did you have any like thoughts before like that you were actually going to go to law school or
Not really.
Okay.
No.
So no real interest. It wasn't like you grew up, Perry Mason. I'm gonna go out and do this.
Definitely not.
Yeah. Okay.
So like many of us, I don't know what I want to do. I guess I'll go to law school.
Yeah.
Right. It's a rehabilitation exercise.
Right.
So the University of Maryland Law School is in Baltimore, and I went here and I clerked for a law firm and graduated, and I got a clerkship with a federal judge who's no longer alive, Arthur C. Watkins. And that was a tremendous experience. He was kind of a patrician, older guy. He'd been on the bench for a long time, but a fascinating man. And he tried this criminal case, and we walked out going back into chambers after he charged the jury. And I turned to him, I said, well, Judge, what do you think? Is he guilty? And the judge turned to me and said, son, I don't know. The jury hasn't told me.
Mm.
It was quite an experience. And the court had just gotten Westlaw and Lexis. And Judge Watkins had written a major due process opinion, but as an older guy, did not know how to use it. So I said, sit down here at the terminal, I'm going to show you. I'm going to type in opinion by Watkins. And let's say I have a due process case and I'm appearing before you, and I type in due process. And I'd say, and I typed it in and was searching, and I'd said to the judge, you have to be careful what you type in when you're doing these searches because you can get a lot of garbage back. And he said, not if you type opinion by Watkins.
Nice.
Yep.
Back into his office, and he turned to the secretary and said, Rose, cut his salary in half. Damn machine does its job for him. So that was quite an experience. And after the clerkship, I went to
sorry, what year did you graduate?
Graduated in 80.
In 80.
Mhm.
Okay.
So then I went to work for a small law firm, stayed there for about 17 or 18 years. It got eaten by a larger law firm. And
Is that in Baltimore?
yeah, Tidings and Rosenberg, a Kaplan Greenberg. And I stayed there for a while, and then I was getting a divorce and had 3 little kids, and I just couldn't do large law firm stuff. So I applied and became the deputy chief of civil litigation under Joe Curran at the Maryland Attorney General's office. And I stayed there for about 7 years, and that was fascinating. Judge Paul Grimm used to say the working for the AG was doing God's work. It was really just amazing stuff. Election cases. I did a week-long trial defending Maryland's touchscreen election against the machine ate my ballot. And that went to the state Supreme Court and we won. Fascinating case. I represented the state where the state of Maryland was sued in the Colorado courts because Maryland had failed to follow an interstate compact, and Maryland sent a probationer to Colorado without notifying Colorado. And he sent him there for drug treatment. And the compact says you have to notify the receiving state and ask for their permission. The long and the short of it is there could not be any rape, murder that was horrific, but this man dropped out of the program and killed a young college student. And family sued Maryland in the state courts of Colorado. And under a Supreme Court opinion that I think has since been reversed called Nevada versus Hall, the U.S. Supreme Court had said a state does not have sovereign immunity when it's sued in another state's courts. So I was defending a case. The governor of Maryland had sent a public apology to the governor of Colorado. The violation of the interstate compact was on the court record, and the damages were horrific. And we ended up settling the case eventually. But the issues, for instance, of sovereign immunity, all that were fascinating. I did ballot access litigation. And
Who was the governor then?
I believe it was Glendenning.
Oh, it's already Glendenning by then. Okay.
So it was fascinating, and there I did police cases. I did a high-tech defense of a police shooting case where the Transportation Authority police shot and killed the man who was driving the car. And there'd been an 18-mile low-speed chase, and the suspect car drove up to the Fort McHenry toll plaza. Several officers came out with their guns pointed at the car, yelled stop. The car accelerated, and they shot and killed him. And the video from the dash cam of the car behind the suspect's car showed only the tops of the officers' heads. And the video from an angle was deflected. So now, Rocky, that picture is behind your head. But if I took a picture from over here, it would no longer be behind it.
Right.
So the plaintiff contended that the officers were not in danger when the shot was fired. And one officer said, I was directly in front of the car. So it was all digital video. I sent it to a company. I'm sorry, it was all analog video. I sent it to a company that digitized it. We surveyed and measured the police car, the officers, the toll plaza, and they reconstructed the accident and showed that Officer Haynes was 23 feet in front of the car. The car was traveling at 22 feet per second, and Officer Haynes was 1 foot 6 inches inside the path of the car. So he would have been killed had the other officer not fired the fatal shots.
Right.
So we lost on qualified immunity in the trial court, and it was reversed in the Fourth Circuit. The officers had qualified immunity and prevailed. But
So when did you drift into e-discovery? I mean, you had a little digitization there on that video.
So that was definitely using electronic information, and we did so in a very advanced fashion. But e-discovery came about a little bit differently. I, for many years, chaired the federal court committee of the Bar Association, Bench Bar Committee.
Yeah.
And when Judge Paul Grimm was a magistrate judge, the December 2006 federal rules came out. And Judge Grimm decided to form a committee of all aspects of the bar to come up with protocol. So he got this committee together, and I had the honor of serving on it. He calls it as scrivener. And we developed what became the ESI protocol of the District of Maryland. It's posted on the website. It's been cited by some court opinions, and started getting into it. He had written some ESI cases even earlier, Thompson versus HUD and some cases like that.
Yep.
And the University of Baltimore asked us to do a symposium on ESI. So we put it together. We got Professor Marcus from the Rules Committee and a number of guest speakers, and we put on the symposium. And they then said, well, will you teach a class? So I take it back. They said, will you write some law review articles? We wrote one that ended up being 2 law review articles. And then they said, will you teach a class? So we developed a class together. And then the University of Maryland said, will you teach a class here? So we taught a class here. And then the judge's schedule got too hectic. So he became a guest lecturer, and I took over the classes. And I have no computer skills, no other than ordinary skills that I picked up along the way, no forensic training other than.
Well, we already established you were a lawyer.
There you go. There you go. But got into it. And I was going to say jokingly that I got into, I did a lot of reading, like
Yep.
Electronically Stored.
Nice.
I got an excellent book by T.O. called
Oh, yeah.
I've seen that book before.
It's an oldie but goodie.
And I just started, I use all my props at one time. I just started reading. And there are great books, Parquette's book on, ethics, and ABA books on spoliation. And I just started reading and teaching and got more and more involved in it, did some presentations, learned, got to meet people, learned from them. And it kind of went from there. Once people think you know something about something, they invite you to talk on it, and then you need to learn what you're going to talk about. So you go study it and research it and read it. And I would also start doing guest lectures, like I'd have Craig Ball do forensic lectures like he did this week for my UB class, and learn a lot from that. And I'd bring in guests who celebrate, and I'd listen to what they said and listen to their lectures. And, that's kind of how I got into it. And of course,
But sorry, I was just going to say, it sounds like on the most part, it's the lack of fear. It's the, you weren't scared of technology. Most attorneys, who were coming up through the 80s, 90s, early 2000s, they were very hesitant to get involved in anything that had to do with technology, whether it be on the forensics, e-discovery side, whatever it might be. But it sounds like you just grabbed onto it. It's that lack of hesitation and interest in learning that really pushed you to now become the expert that you are.
well, thank you. What I tell students is this is just a discipline to study. It's a rule-based discipline. It's not the Erie doctrine. It's not antitrust law. Okay, it's a rule-based doctrine. And I say to them, you're going to do cases where you depose an accounting expert or a legal expert. You're going to do a complex medical fracture case, and you know nothing about medicine, but you're going to have to learn enough about it to depose them. I had to depose experts in police wrongful death cases. I knew nothing about it. So you sat down and you read and learned. And this is an area where there's some basic principles. What is your duty to preserve trigger? What is the scope of your duty to preserve? What are the limits? What are the consequences of spoliation? When is there spoliation? How do you implement a legal hold? How often do you have to give reminders? They're very basic things. Now, that's not to say it's not complex and full of traps and places for error, but it is an area that you can study and learn and master. And as the technological competence cases say, associate with people who know stuff that you don't know.
Yeah.
And let me ask a question here, Michael. So you've been at this for a while. Have you seen an increase or an uptick in that level of expertise? I don't even want to say expertise, just understanding of this area from the general practitioners, from your colleagues. I mean, you're out there practicing law. Has the rising tide lifted all the ships?
No. And I think,
well,
Pretty
okay,
straightforward. Yeah.
here we go.
I think all of us are egotistical and believe that we can logic our way through things. And, I attended your EDRM case law seminar 2 days ago.
Yeah.
And you talked about a case, I wrote down the name so I remembered, Sickles versus McDonough, where an individual used his employer's email system to communicate with his attorney. When the lawsuit ripened and the employer seized all the information, they said, we have a no personal use policy, and you violated it, you waived the privilege, and the court said, you're right. And Judge Peck in that class said, there were some old cases on that. And the day before, in my University of Baltimore Law School class, I taught Scott versus Beth Israel Hospital, where Dr. Scott was employed by Beth Israel. Dr. Scott used the employer's system. Dr. Scott wrote to his lawyer on the employer system. He sued the employer seized the email, and the court said you waived the privilege. So 10, 15 years after Scott versus Beth Israel, we're still coming up
Yeah.
with the exact same thing. And it shows that there's a huge need for education in this area, because I can't tell you how many times clients or attorneys have said, "Oh, we preserve everything. We don't get rid of anything." And you go, "Well, that's wrong. No, we don't want to do anything." And then 6 months later, it's all disappeared. Or you go down to the IT person and he says, "Yeah, I tell them we preserve everything, but we've got a terabyte of storage. When we hit, 90% of it, I start throwing stuff away. Just don't tell them, And so, no, I think there's still a tremendous gap in knowledge and education in this
So
area.
now I'll put you on the spot. How much, I'm sorry, Rocky, just real quick. How much is that of that is because law schools don't teach this? You're in a hotbed of legal education, really, where you are. I mean, you mentioned Judge Grimm, who was on top of this, and the University of Maryland, and now you're teaching it at Baltimore. I mean, that's not the case all around the country.
Right. And I'm going to ask, just related, same vein of question. Is it that those examples sounds like individual attorneys, personal attorneys. How much of it is a lack of education or a lack of awareness between the solo practitioners versus big law? And do you see that there's a difference there in terms of the level of competence when it comes to technology and how the law pertains to the usage of the technology?
So they're both great questions. And I think blaming law schools is a bit too simplistic. I don't think law schools overall prepare you to practice. When I got out of law school, I couldn't have handled the case. I think there's a learning curve. I think the law schools can and should do a lot more to help. But people who have been out for 5, 6, 7, 8, 9, 10, 15 years, Maryland doesn't have a continuing education department, for instance. Right. So they have an obligation to develop their competence in the area. In terms of solo versus large, I think it varies, and it varies markedly for a number of reasons. There's some solos who are very sophisticated. There's some who are not. There's some large firms who just say, we contract it out. We just, I don't know anything about it. We just hire somebody. So I think it varies greatly. I think it also varies significantly in the type of cases. So I forgot the statistic. There's something like 70% of the Maryland Circuit Court cases are family law cases.
Yeah.
And that is a different dynamic. If you have people who are in a middle economic class who have 2 kids who are divorcing, who are now going to have 2 mortgages or 2 rentals, and it's a whole different ballgame with them. And that's where Tom's, e-discovery for small cases and e-discovery for us type of solution has to come in. And Craig Ball has published on do-it-yourself solutions for Facebook and Google and phones. Right. And Judge Mark Colson here in the District of Maryland published an opinion that said those may be sufficient. I can't say for every case, but they may be sufficient for cases. So again, I think it, in terms of the levels of sophistications, I think it may be very different demands on a family lawyer whose biggest case is a couple whose combined adjusted gross income is $100,000 versus a company that's bringing in, $200 million a year. So it's a very, very complex area.
Yeah, but you also have, there's what divorce case today doesn't involve text messages or doesn't involve, Instagram or search history or something.
Photos, Facebook posts.
Right.
Yeah.
I mean, it is the nature of what the law has become and what the cases are about. And I don't see overall, as a general rule, the attorneys or the law schools really addressing it. I mean, you have your individual experts, sure. You have your individual people who go out and, They're taking the time to actually learn and continue to educate themselves. But as a profession, I don't
Yeah.
see the legal profession actually ad adapting and adopting in the way that they should be, unless, of course, it's got that buzzword in it of Tom's favorite word.
Boston Celtics.
I'll
So,
say artificial
Oh, oh,
intelligence.
oh,
Then
no.
they're all over it. But
Oh,
no.
yeah,
Yeah.
yeah, I know. Well,
so
Michael, part of this is, and I've had this discussion with Craig Ball a couple of times, as judges like Judge Grimm have stepped down from the bench and gone on to do other things, Judge Peck, Judge Francis, Judge Shinlin, who's the new wave coming up? How about who's the young Michael Berman in Maryland? Is there one?
So I think Judge Mark Colson, who was the head of ESI at Miles and Stockbridge before he became a U.S. magistrate judge, is a good example. And he's writing a lot of decisions, and he is very attuned. And he's written articles. He is very attuned to it. But I think, Rocky, part of the answer to your question is that judges are not demanding the competence in the courtroom. So I have had the honor of teaching several times at the Maryland Judicial College, which is the arm of the state Supreme Court. Although lawyers don't have continuing education requirement, judges do. And the judges come to either virtual or in-person classes at the Judicial College. And for example, we did a demonstration, Judge Grimm, Craig Ball, and I did a demonstration, and Alicia Shelton and I did a demonstration of, in a pro se domestic violence case, what do you do when the pro se litigant says, and he sent me threatening messages on my text phone, Judge, here, how do you handle that? And we run through a mock exercise. Alicia and I had Ashley Aranega from X1 Social Discovery as an expert witness, and we created a fake Facebook account. Fake, it was really malicious, and downloaded it. And we did an exercise in front of the judges of authenticating Facebook messages. So, Rocky, part of the reason lawyers are not doing it is the judges are not requiring them
Right.
to go through the steps to authenticate and properly author evidence.
But is that because, and I don't want to sound ageist here, but overall, judges, yes, you're starting to get that new generation coming in, but overall, judges, let's say, are 50, 60 plus, or 50 plus, let's say, and therefore, when they were practicing, they didn't have to deal with it. So now, even though the world has advanced over the last 10, 15 years that some of them have been judges, they're not expecting it from the attorneys who are standing in front of them.
Well,
It could be.
Michael, I don't know if you see this, and sorry to interrupt, but if you see this in Maryland, a couple of places I've noticed that if there's a couple of districts I've noticed, if there's a young magistrate judge who's knowledgeable, who does have that background and usage that Rocky just mentioned, they sort of become the go-to e-discovery person. That the sitting judges sort of steer things to that magistrate. You mentioned Judge Colson,
Judge Schlegel by you.
Judge Schlegel, who's a state court judge, but still.
But still,
Judge Allison Goddard out in San Diego. I mean, there seems to be a bit of that. I mean, you see that in Maryland as well. Is there the steering to the people who do know it?
I have not seen that. So in the state court system, most cases are not specially assigned.
Yeah.
You get motions judge or discovery judge. In the federal system, the breadth of the U.S. magistrate judges on discovery, I couldn't begin to name them all. They're all very, very attuned to it. And my mentioning Judge Colson doesn't mean to ignore any of the others who are issuing opinions regularly. So I think it's a combination of multiple things: education of lawyers, education of judges, costs. This can be tremendously costly. And then we've created a system that is incredibly complex, and to do absolutely everything in every case. And I
Yeah.
had a friend who used to do divorce work, and people would come in and they'd say, I want to fight custody, I want to fight alimony, I want to fight property, I want to fight. And my friend would say to them, okay, it's $250,000. And they'd fall down. Now,
Right.
I want to focus on this, this, and this. We can do it for $10,000. Okay? But if you want to fight everything, and we've
Right.
just the system, if you go to the library and you look at the Supreme Court reports for the first term of the Supreme Court, admittedly a different time, they're this big. And if you go now and you look at the Supreme Court reports, they're this big. And we've created a system where to dot all the I's and cross all the T's can become impractical. And I think what you see in a lot of cases is people saying, yeah, there's really no issue over these text messages. You send them, I got them. There's no issue. Here they are.
Right.
You mentioned judicial education. I just want to touch on that briefly. I think that's a really important point, though, especially at the state level. To have some resources that the judges can learn about these things. The judges are hesitant to go to courses that involve the members of the bar. People are going to be sitting in front of them. The judges like to go to classes with judges, and certainly, Judge Grimm, now in charge of the Bowles Judicial Institute down at the Duke Law School, I think is taking a lead in that. So I was heartened to hear you talk about a presentation you made to judges, Mike.
Yeah.
So we've done several, either with my colleague Alicia Shelton, who's an assistant U.S. attorney, or with Craig Ball and Judge Grimm. Most recently, the Supreme Court of Maryland issued a criminal cell phone case called Richardson. And Justice Braine's majority opinion said, when you issue a search warrant for a cell phone, you can't say, get the whole cell phone. You have to focus it. So the Judicial College came to me and they said, the justice wants us to do a class for the judiciary. Can you set it up? And I said, I do civil, I do criminal, but let's see. So we got 2 assistant U.S. attorneys. We got a Department of Justice cell phone forensic expert and a University of Baltimore Law School professor. And we did, I think it was about an hour and a half virtual seminar for the judges of Maryland, trial court judges and appellate judges, on how to tailor a search warrant for a cell phone.
Yeah.
And they are getting education. We've done authenticating social media, we've done authenticating cell phone evidence, we've done duty to preserve sanctions, and they're getting it. And I think more and more appellate decisions are coming out in the Maryland appellate courts that will also, on the national level, ESI became a big thing with Judge Schindler Zubelik cases, and what Dan Willoughby called the marquee cases of sanctions, the whole 2000, 2004, 2005 sanctions case, right, where people went down in flames, and that got people's attention. Yeah. And now you're starting to see state appellate decisions coming out on ESI issues.
Interesting. Okay.
Although I think the early cases kind of, to a degree, there's a lot of fear mongering amongst them. Mm-hmm. Like, there were, I think, somewhat on the vendor side. You had vendors who were like, "Oh, you need us to handle all this e-discovery stuff for you, because otherwise you're going to get sanctioned on every single case." And I think that, if anything, it may have actually hurt the legal education side, because attorneys were like, okay, well, if I hand it off to the experts, then I don't need to necessarily learn it myself.
Yeah, I think judges have squashed that concept recently.
Correct. It's definitely shifted in a good way.
Yeah. Hey, real quick.
I want to ask.
I'm sorry, just real quick.
Yeah.
No. I just want to comment on something Michael
This
just
is how
said.
it normally goes, by the way.
Yeah. No. Sit down, knuckleheads.
Okay, fine.
No. Just the fact that you had said earlier about, small cases and small lawyers and all the domestic cases. You just mentioned criminal, which has exploded as an ESI source, something that didn't happen 10 years ago. Right. Cell phone, like you said, Rachi, cell phones, everybody's got one, even the criminal.
What case doesn't involve text messages?
Exactly.
One of the things that fascinates me, and I invite a couple of practitioners in criminal law, I can't say criminal lawyers, practitioners in criminal law, um, to do a presentation in the class. And one of the things that amazes me is there is less discovery where your liberty is at stake than where your money is.
Yeah.
And criminal defendants get much, much less of an opportunity to tailor electronic discovery than civil litigants do. And it is a really interesting policy difference.
But I think that's just money because the corporations where a lot of money is at stake have the money to spend on it versus the criminal defense, the
Public
defendee.
defenders, public defenders.
Well, public defenders for sure.
Yeah.
But your general run of the mill,
Criminal.
criminal or potential criminal or whatever you want to call them, they don't have, oh, I'll spend $50,000 to do any of this. So
I do pro bono work for the federal defenders. In the insurrection cases, I don't even know how many defendants there are now. It started off at about 700 or so. Half of them had public defenders, federal defenders.
Right.
And that was all cell phone, email, video, text message. So yeah, it's a huge problem. It's a huge problem.
So Mike, I wanted to ask you, we talked a lot so far about, general education and things that you do to educate, whether it be your classes or judges. What's your go-to sources for educating yourself? Obviously, there's the reading, but reading doesn't necessarily stay up to date. What are your sources that you're going to on a daily or weekly basis to help keep you in touch with what's going on?
So I try to talk to people. When you're litigating a case, of course, you get to talk to experts and other lawyers, and occasionally a judge or two, about things. I find the best sources are things like Tom's EDRM case law review. Every month I sign up for it. Because no matter how much you do, and I have standard Westlaw searches that bring cases back, you miss 50% of it, how much you do. There are blogs. Doug Austin's daily blog is a great resource. Follow people on LinkedIn who post stuff. That's really where you get the current information. Kelly Twigger has her case of the week in her presentations, and see what people are saying. I think that's really the way to keep up. Books are great, and they're great resources, and I've edited 3 books on eDiscovery, but they're old by the time they're published.
Right.
Hey.
He's not talking about the author. He's talking about the book.
Oh, okay.
So,
No, it is. It's a real issue in the publishing world. I mean, I just went through have done an update to the book, and yeah, I mean, decisions, like you said, Michael, decisions come out every week.
Right.
I've never seen an area of the law that had so much case law, so intense, nonstop. You don't see this in a state law. You don't see this in constitutional.
Because things aren't the things around it aren't changing the way that technology is.
I liked your mention of LinkedIn there, though, Mike. That's, to me, LinkedIn has become, this is just me, but LinkedIn has become the old coffee shop near the courthouse, where all the lawyers used to go. You'd go down there in the morning, even if you didn't have a case, you'd go down and hang out, and there'd always be 5, 6, 7 litigators hanging around. A couple of them had a case. Maybe somebody was there for a motion call, but and they usually closed at like 1 o'clock. They didn't, breakfast and coffee, lunch and coffee, then they'd close. And LinkedIn has sort of become that, for me at least, way to, like you said, find those people, to reach out to those people talking about these issues.
It's a great resource. I'd say 80% of the people are there to sell something, and 20% are not. And it's worth wading through everything to get what you want.
And even some of the people selling still have intelligent things to offer. So
absolutely.
Some.
He said self-servedly.
Exactly.
you know.
No, you're right.
Once in a while, yeah.
You have to distinguish between that, but that's the American way. I mean, I watch TV the same way. I put up with the commercials because the content is worth it. And, so yeah, you're right, Michael. 80% may even be low, but but we've learned to put up with that, to go and find the people with the content and have the discussions we want to have.
But it's an area that develops so rapidly, and after all, everybody who's practicing it has some degree of, familiarity with electronic communications and social media and the like. So I think that is the best way to keep up. I subscribe through teaching to Bloomberg Law. They have great articles. The ALM comes out with some really interesting stuff. There are all kinds of subscription services. If you teach, you can get them for free. If not, maybe a law firm or something pay for
good.
service. But there are all kinds of things. And then vendors put out a lot of good stuff. John Trednick years ago did Tar for Smart People, free book to download. Xterra has a very nice blog with a lot of case law. They do publications that are free. The Sedona Conference, as we all know, tons of free papers on virtually everything. They just did an update that I haven't had time to read on possession, custody, and control. And as you know, they're in favor of the legal control standard. Judge Green here published practical control as the test in the Maryland federal court. And all these debates that are going on, and you get these free papers that are current, that are written by very thoughtful people with a lot of work, and you can read them and make your own decisions.
Yep.
Well, we are rapidly nearing.
Boy, this is, as you can tell, Michael, we could go on for hours talking about these subjects. It really is such an expanding.
So my goal is to keep talking so you can't ask any tough questions.
You are a litigator.
Yes, I was going to say, we see the training truly coming out here.
I was going to tell you, and Rachi said no fear, that this is more terrifying than an appellate argument or a motion argument. Because when you go into court, there are rules, there's a topic, you know what the parameters are. No one can go outside the parameters. But here, you guys
anything can happen. You never know.
Happen.
Tom might get up and start dancing for all we know.
Well, that'll never happen. You've never seen me dance.
That was Gail's department.
That was Gail's end of the business.
Yes.
That's right.
Yes.
Well, Rocky, go ahead. I'm sure you've got some of the questions Michael has been dreading. Some free form.
Yes. Well, let's start with some nice and easy ones. So you live in Baltimore. You've lived here for quite a while. If you could live anywhere in the world, where would it be?
Well, I would say either Baltimore, because I do love it here. It's a fabulous area. Washington, D.C. And I always used to say, when they built the East Wing to the National Gallery of Art, it was $100 million. And I always used to say there are very few cities we build a $100 million museum. And this was many years ago. Be a lot more now. There are very few cities where you build a $100 million museum, call it the East Wing. It is a fabulous city, what it has to offer, and the current that runs through the city is really tremendous. I think that would be it.
Very cool.
Right.
If you could give one piece of advice to your younger self, now knowing everything that you know throughout your life, what would that one piece of advice be?
That is a tough one. So Clarence Darrow said, I've generally represented the poor and the weak, but not always. Sometimes I've represented the rich and the powerful, but I've never represented the rich and the powerful against the poor and the weak. And I think that would be kind of it, to have a sense of justice of what you do. I did, starting out, a ton of pro bono cases where I would do prisoner civil rights cases, pro bono, and things like that. And I think it's really important to do that, both because it's important to society as a whole, but also to building your professional skills. So when I was in a law firm, no one's saying, okay, you can go try a case, Mike, all right, if it was worth more than $50. But when I was doing a prisoner inmate civil rights case, it was mine. I did the interrogatories, I did the depositions, I did the doc review, and I did the motions. And if there was a trial, I did the trial. So that would be at the Clarence Darrow kind of thing, to try to do the right thing, do justice, and build your professional career.
I like it. Favorite book?
So,
And it can't be Tom. It can't be Tom's book on small case discovery.
Dang.
Probably Kurt Vonnegut, Breakfast with Champions.
Oh,
Okay.
Kurt Vonnegut was fabulous. He had great breadth and a great mind. He was a great writer. He did a part in Breakfast with Champions where he did a picture of a rattlesnake, and he said the rattlesnake is a creature of the creator of the universe. It has hollow fangs that do nothing but inject venom and harmless animals. Sometimes I wonder about the creator of the universe. He was a very thoughtful guy. I saw him speak, and I think that would probably be it. Although there's a close run with Richard Brautigan, who was a 60s and 70s California poet who committed suicide, I think, in 1984.
yeah.
And he did books like Loading Mercury with a Pitchfork and Watermelon Sugar. My life is done as all my deeds are done in watermelon sugar. And he was
Trout fishing in America.
trout fishing. Yeah. So probably a tie between the two of them if I can cheat on the question.
Wow.
That's fair. We'll let you cheat on that one. Okay, Tom, take it away with our final question, or maybe a surprise.
We have a sneak high inside pitch from Jim Palmer here that's going to come up under the chin. I just saw it thing. Are you a baseball fan, Michael?
No.
All right, never mind then. I won't say this there. Real quick one: Beatles or Stones?
So I was afraid you would ask. So probably I would go with the Beatles, but the answer would be neither. So I graduated high school in 66, went to college 66 to 70, and I would have to replace both of them with people like John Prine and Phil Oakes. I think they were, nothing against the Beatles or the Stones, but I think they were true artists who had a social consciousness that tried to shape the country. And their music attempted to send a message that was important. So Prine did Muhlenberg County, Take Me Down to Muhlenberg County, Where Paradise Lay. I can't, Mr. Peabody's Coal Company has hauled it away. John Prine recently did When I Get to Heaven, kind of funny song about death. And when he gets to heaven, he's going to get a gin and tonic and a cigarette that's 9 miles long because this old boy is going to town. I think that they had a message that was different. Phil Oakes, The Draft Dodger Red, making fun of a very serious topic in a very understandable way. Flag decal will get you into heaven. I think these artists were sending a message. You can agree with part of what they said, or all of what they said, or none of what they said, but I think they were trying to communicate important things to the country, and I think that was really significant in both music and growth of the country. And I think music did. I'm going to tell you, if I can interrupt you 1 second.
No, go ahead. I was just going to make a comment. Go right ahead.
I went to an Arlo Guthrie concert, and he did Alice's Restaurant, which probably half the people on this have never heard of.
And Thanksgiving, come on.
There you go.
You have to listen to Alice's Restaurant.
At the end, he said, I've been singing Alice's Restaurant, and it took 18 and a half minutes. And he said, music can change the world. He said, when Dick Nixon resigned, he said, a friend of mine was cleaning out the White House. He was a mover. And he said, you'll never believe what we found. He said, we found a copy of Alice's Restaurant in Nixon's private library. And Arlo Guthrie said, I got to wonder, what was Dick Nixon listening to for 18 and a half minutes that he didn't want anybody to know about? And you can change the world. And I think Phil Oakes and John Prine were people who, whether they changed it or not, they tried to change it. Beatles were good entertainment. Rolling Stones, they were great. That's my 2 cents.
And of
Okay.
course, Arlo's dad, kind of started all of that. But my comment was going to be, if there was ever any doubt that you went to college at the University of Wisconsin Madison, you just put that to rest entirely. So our last question is, if you could spend a day with anybody from our profession, who would that person be, and what would you do? It doesn't have to be, reviewing documents. Who and what?
So I'm going to give you an answer that you've gotten before, Abe Lincoln. But before I get to Abe Lincoln, I'm going to tell you who I would want to spend a day with, and that is Gouverneur Warren. And Gouverneur Warren was one of the heroes of the Little Round Top at Gettysburg. And he went down to Little Round Top, found it was undefended, and brought Strong Vincent's brigade up literally minutes before the Confederates came up Little Round Top. And he was credited with saving Little Round Top. There were a lot of other heroes who deserve credit there, but he was promoted and led troops in a subsequent battle called Five Forks. And General Sheridan said he was a coward, he didn't do his job, and removed him. And he was disgraced. And he spent 14 years fighting for his name, and his name was cleared by a court of inquiry 3 months after he died. So I think that's the difficulty in trying to evaluate these things of, what is truth. So Abe Lincoln would be my choice, and everybody knows all the stories about him. People have been to the Lincoln Memorial. It's stunning, and he was clearly a great president. The Emancipation Proclamation and the Gettysburg Address, and his greatness is known. But I was reading a book called The Subjugation of Maryland, and Lincoln was terrified that Maryland would secede, because if Maryland seceded, Washington would be surrounded. So they had a campaign, and this author believes Lincoln was behind a good deal of it, to disarm Maryland, to occupy Maryland with federal troops. There were riots in Baltimore. Troops were stoned and shot civilians, and Maryland was essentially occupied during the Civil War. And as we all know, on a footnote of history, President Lincoln suspended the writ of habeas corpus. And this author goes through what that meant. And 14,000 people were arrested with no trial, arrested by military tribunals for, quote, disloyalty. Fort McHenry, the home of the Star-Spangled Banner, became a prison for Marylanders. And Francis Scott Key's grandson was imprisoned for disloyalty in Fort McHenry, where his grandfather had written Star-Spangled Banner. And I would be interested in retrospect, because it also has contemporary implications. Lincoln was faced with an existential crisis, probably the most horrific crisis America has faced. Tens of thousands of people dying in a day without. But I'd like to ask him, in retrospect, what he thinks about destroying the Constitution in order to save it, of suspending habeas corpus, where they could just come up with a military tribunal and say, Tom, you're disloyal. We think you're a secessionist. You're going to jail. And I would like to ask him, with the benefit of a couple hundred years of history, what his view of it would be now, whether he would do the same thing. So that's the conversation.
Great answer.
And it may very well have been the right decision at that time.
Yeah, it's tough. Again, through the filter of history, it's tough to say who we were at war. And as you said, people don't stop and think about that Washington, D.C. was almost a southern city.
Right.
And Confederate troops had come to their doorstep several times.
Correct. And part of the Maryland legislature was arrested to prevent them from voting for secession, even though the legislature said we're not going to vote for secession.
Yep.
And Maryland was fully split. It was not a clear thing of what was going to happen in Maryland.
No.
So yeah, that's interesting, because if he hadn't done it, we may have a very
could have gone another way.
Yeah.
Right.
Yeah. Very interesting.
Cool.
Well, Michael, thanks so much for taking the time to speak with us. Always a pleasure. And I hope we get the chance to see each other in person again. As I said, one of my my jaunts to DC, which have become few and far between now. I always try to take some time to get up to Baltimore. So next time I will definitely go out of my way and introduce you to, if not Rocky, at least his brother Shimmy, who lives not far from you. And
Sounds good, and I can always come to DC. And thank you guys. I appreciate it. This was fun, and I really enjoyed it.
my pleasure.
Same here.
Rocky, thanks for the time. I will see you in a few days in
Hopefully,
New York,
yep.
at the yearly Legal Week Tech Show and Car Exposition.
Come on, be excited, Tom.
Yeah, no.
Carnegie Club. Carnegie
Say what?
Club.
Carnegie Club. I'm excited
Now
about.
you're
I'm
excited,
excited
right.
about seeing you and Shimmy and a number of other my friends. I'm excited about the Carnegie Club. I'm excited about good food in New York. You know,
Hey, always look on the bright side of life, right?
look on the sunny side of life. There you go.
Well,
Well, thank
thank
you,
you.
everyone. Thanks
Good.
for listening. And if any of you are at Legal Week, you will undoubtedly see myself and Rocky and his twin brother Shimmy walking around, being making
Causing trouble. Yeah.
making fun of people. Yeah.
Yeah.
Thanks again for tuning in. We'll see you next time on the eDiscovery channel.